that Makala case does not constitute authority, my lord. The authority is what was penned by the majority judgment. When we're talking about this judgment, and we're talking about the judgment of Makala that was decided by the Constitutional Court, we're referring to the majority judgment. That is what is called a majority judgment. And that is also in terms of the doctrine of stare decisis. I do support the state's view that that their submission indeed should have been made very reluctantly because of their realization that that cannot be law. In other words, the statement of Mr. Kwabeni cannot be a subject of a trial within a trial. That the state appreciates as well, my lord. Furthermore, the state mentions in paragraph 6.1 of their heads of argument that it is therefore respectfully submitted that the state be allowed to cross-examine Kwabeni on his statement. And this, the state says, is the nub of their argument. This basically presupposes that somebody said to them, no, you cannot cross-examine Mr. Kwabeni on the content of the statement. And that is not the case, my lord. Nobody said that. And this is what happened. My lord, it all started with the process of the state cross-examining Mr. Kwabeni after having cross-examined, put to him plus minus 10 questions, preliminary questions, I suppose. Then the state addressed the court and told the court that the larger portion of their cross-examination would then be based on the statement that Mr. Kwabeni allegedly made. Immediately thereafter, then the state started to cross-examine or embark upon a process of cross-examining Mr. Kwabeni on the content of the statement. I then stood up and said, this process is precarious, and those are the words that I used, my lord. I said, this is very precarious because even before the state would have to start to cross-examine Mr. Kwabeni on the content of the statement, the state has got to prove that statement. It started there, my lord. The state then responded. But then the court said, Mr. Baloyi, you'll have to prove the statement. He still did not understand. Then the court again said to him, Mr. Baloyi, you'll have to prove the statement. Then Mr. Baloyi ultimately said, no, I think on this aspect, I think it is, I propose, him being the state, said that I propose that we should rather file heads of argument in which this aspect is going to be ventilated, my lord. Then there was a proposal about the dates and everything. When a comment was requested from me, I told the court specifically that I still stand by my argument, or by my submission then, that the state has got to prove the case before it goes into the content of the statement, if they want to impeach or test the credibility of Mr. Kwabeni on the basis of his statement. My colleague were amenable to the suggestion by Mr. Baloyi that heads of arguments should be filed. Fast forward, heads of arguments were filed, and here we are, my lord. By submitting or by making these submissions, my lord, at this moment, this should not be understood to mean that I'm reneging from my initial submission that the state still needs to prove the statement of Mr. Kwabeni even before they embark on cross-examining him on the content of his alleged statement, my lord. Now, this is what I wish to submit, my lord. Now, the state says that Mr. Kwabeni has been called or made the statement in terms of section 204. And they had to call him as such. However, because of the information that came from Mr. Kininda, that Mr. Kwabeni could not come testify because he feared for his life. That is the reason why they did not call him, my lord. That is neither here nor there, my lord. And I do not wish to get into that. But fast forward in their argument, the state says, we could only have used Mr. Kwabeni also as a section 204, and with the content of the statement that he allegedly made. I'm still struggling to understand that, my lord, because the minute the state made Mr. Kwabeni available to us after they've decided not to use him, and we consulted with Mr. Kwabeni is no longer a state witness. Mr. Kwabeni could no longer have been branded as a Section 204 witness or what. Therefore, any branding of Mr. Kwabeni as a 204 witness at this moment in time is misplaced, my lord. Because, as I've said, when this same point was raised, when Mr. Kwabeni was being cross-examined, the court will recall that, not really cross-examined, led. When I led Mr. Kwabeni in evidence in chief, the state stood up and said, it wonders if the process is proper that I should lead Mr. Kwabeni as a normal witness instead of me requesting the court to warn him in terms of Section 204. And then I said, no, but look, Mr. State, to us, Mr. Kwabeni is not a Section 204. To us, Mr. Kwabeni is just a normal witness. Look, you wanted to use him as a Section 204, but for reasons that are only known to you, you decided not to use him when you were presenting your own case. And then you later on make him available to us. And in fact, my lord, to be very specific, these are the words that I use. I said, you decided not to use him. And we went there at the trash place. This is the way that I use. We went at the trash place, we picked him up, we cleaned him, we brought him here so that he can come and assist the court to tell exactly what happened on the 26th of October 2014. Now the state says no. The defense can only use Mr. Kwabeni if Mr. Kwabeni is branded by the defense also as a 204 witness, my lord. We did not call him as a 204 witness, my lord. There is no such a provision in the Criminal Procedure Act that if a state fails to use a witness who they had anticipated to use as a Section 204, then when they do not use him and they make that witness available to the state, then they decide to make that witness available to the defense, then the defense should also use that witness as a Section 204 witness, my lord. That is pretty wrong. That will be very unfair, because the status that the state had accorded him by virtue of them not having called him lapses. Any person that is involved in the trial could pick up that witness, interview him. If his testimony is relevant to the trial, then he can simply request that witness to come and testify before court in order to assist this court to come to a just and an equitable finding, my lord. Now, the state had requested this court very, very passionately that the court should understand its plea to file heads of argument in order to deal with this issue, my lord. Now, as I was expecting, I thought that the state would come up with something totally, something that is totally out of the realm of the ordinary, from the process that is known with regard to how a statement of a witness is being dealt with if the credibility of that witness is to be challenged, my lord. At some moment, I thought that the state would come up with an authority that says, no, there is an exception to the fact that before a witness is impeached, on his statement. We don't have to prove his statement. I've gone through their heads of argument. There is nothing such as that, my lord. All that the state is talking about, they are repeating the evidence of Brigadier Kilinda, which is already on record. They are repeating the evidence of Mr. Zungu, which is already on record. They are talking about the interest of justice, that we all know. They are also talking about the evidence of Mr. Kwabeni, that is already on record, and a whole lot of ideas. But one point that the case is, that the state is missing, is to come up with exceptional circumstances where a witness can be cross-examined on the basis of his statement without proving that statement. But the issues in this case are very circumscribed. They are very specific and they are less complicated. Before a witness is challenged on the basis of his statement, that statement must be proved. It must be established. Now the state says, no, but Mr. Mnisi, when he led Mr. Kwabeni, he already proved that statement. I'm seated here and wondering at what point did I do that? Now I recall that probably the state did not understand what was happening here, because this is exactly what happened. Mr. Kwabeni said, and this is what is also encapsulated in the state's heads of argument. Mr. Kwabeni said, no, because I was being assaulted, and I'm going to specifically refer to such a passage in the state's heads of argument, my lord. Then I ended up saying to my torturers that, can you please transfer everything that Mose has said in his statement into the statement that you say I must make, and then I will sign it. Apparently, something was done. And then Mr. Kwabeni says, I then put an S in that particular statement. Then I went back to Mr. Kwabeni and said, Mr. Kwabeni, did you make a statement? Mr. Kwabeni said, I told my torturers that they should transfer what Moses accused number one, what accused number one has said in his statement into the document that they want me to sign, and I would sign it. And I was doing that with a view to stop the torture, and I put an S there. And then I went back to Mr. Kwabeni and said, Mr. Kwabeni, did you then make a statement? He said to me, but Mr. Mnisi, I did exactly what I told you what I did. Stop asking me a lot of questions. And then I said, no, wait, Mr. Kwabeni, wait. Let me tell you lawfully how a statement has been made. And then I took him through the steps on how a statement has been made. And I remember quite vividly the court saying, but Mr. Mnisi, you seem to be cross-examining your witness. And I constantly told the court that I wasn't cross-examining my witness, madam, because I was simply showing the witness how I was actually trying to bring to the attention of this witness how a statement is being made. And this is what I said to him, Mr. Kwabeni, this is how a statement has been made. The police will be sitting down that other side. He'll be having a paper and a pen in his hand or in his hand. And then he will ask you, what language are you comfortable in? And then you will tell him the language. If there's a need of an interpreter, the interpreter will be there. And then the police will tell you, will you then be in a position to write the statement yourself, or you will narrate it to me and then I write it down, and then you'll make your choice. Assuming the circumstances that you elect that you narrate a story and the police in whose presence you are would then be writing down the statement. You will narrate your story, the police will write down the statement. You narrate the story, the police will write down the statement. But after having done that, at the end of it all, if that statement is written in English, he is supposed to read it back to you with an interpretation in the language that you understand. If it's Zulu, that should be interpreted in Zulu. If it's Tswana, that should be interpreted in Tswana. It must be read back to you for you to confirm the content of that statement. And if you're happy with that statement, at the end of it all, it is then that you would then have to pen your signature, append your signature on that statement as a confirmation that you agree with that statement. That is how a statement is made, Mr. Kwabeni. Do you understand? He said, no, I understand. Then I asked him, is this what happened when this alleged statement was taken from you? He said, no. Then the state wants to use that as a basis to argue that I have already proven the statement to Mr. Kwabeni. Or in fact, that the defense has already proved the statement on Mr. Kwabeni, so there's no longer any need for them to prove the statement. I think that was a horrible misunderstanding, my lord. But all that information is on record, my lord. Now, the state wants to rely on the Constitutional Court decision of Makala. Makala is distinguishable, actually, from this set of facts here. What happened in Makala is Makala's brother was arrested, or there were allegations that Makala's brother and another person were involved in an assassination of a councillor in the presence of Makala. The police got that information. They approached Makala, the maker of the statement. Not Makala the accused, but Makala the maker of the statement. Then in that statement, Makala the maker of the statement, the head actually implicated his brother and to some extent also implicated himself. Then the state called him, Makala, the statement maker, called him as a Section 204 witness. When he arrived at court, Makala then disavowed his statement, disassociated himself from that statement. The trial court said, no, Mr. Makala, I can't believe you. You have voluntarily made the statement, but this is what happened at the trial court. Realizing that Mr. Makala was dissociating himself from the statement as a witness that was called by the state in terms of Section 204. Then the state made an application to have him declared a hostile witness. But then the court allowed that. The state then went on to lay the foundation of that statement. In other words, the state then went on to prove that statement. Makala said, yes, I made that statement, but I made it under duress, and at some instances I also lied in that statement. That is exactly what the discourse is all about, my lord. It was not like what the state intends to do in this case, simply to cross-examine Mr. Kwabeni on the basis of his statement in order to test his credibility without having laid the foundation of that statement. Then the court at Makala, the trial court in the Makala matter, then found him guilty. No. It did not find Makala, the statement maker, guilty, but it found his brother and the other councillor guilty on the basis of Makala's statement, which was the sole evidence upon which they were convicted. Then they appealed to the Constitutional Court, to the Supreme Court of Appeal. The Supreme Court of Appeal, unfortunately, for the Makalas, it also agreed with the trial court. Then some wise person said no, but the Supreme Court of Appeal is not the only, is not the absolute court of reference. As this matter involves a constitutional issue, a right to a fair trial, let us go to the Constitutional Court. The Constitutional Court cleared the position of it. The Constitutional Court cleared the position. The Makalas were acquitted. Now, the judgment was penned by 9 judges. 3 dissented. That is what constituted the minority judgment. But however, in totality, they also came to the very same conclusion that the majority judges came to, that in any event he had to be acquitted. So the states, for submitting that it wants this matter to be dealt with in a trial within a trial, which is unprocedural, seeks to rely on the minority judgment that said that most probably, and that was a wishful thinking, my lord, most probably the matter could have been dealt with in a trial within a trial in order to determine how Mr. Makala made the statement and all those things. But the majority of the judges at the Constitutional Court had to consider that aspect. They did not even deem it necessary to mention it in their majority judgment because they know that that would have been unprocedural. The only procedure through which a witness can be impeached by referring to his statement is simply to establish his statement. And this is what was said in the judgment of, I'm going to be very short, my lord. This was what was said in the judgment of Moses versus S. It's a Northern Cape decision in Kimberley. A judgment that was penned on the 8th of September 2023 in case number CA&R 42 of 2022. It was heard on the 8th of May 2023 and the judgment was delivered on the 8th of September 2023. This court made a specific reference to the State of State versus Govenda and others, 2006-1, SACR 322, also in Eastern Cape matter. And this is why it says in paragraph 6. In other words, this Moses case referred to the Govenda case with approval in paragraph 6 of the court's judgment. This is what it said. Open quote. In the present matter, the cross-examination of the state witness, insofar as it was directed at the content of their police statement, was done properly, and this is how it was done. In each instance, the witness was asked to confirm that he had made a statement to the police. The witness was then asked whether that which he told the police was written down, whether it was read back to him, whether he was asked to confirm the correctness thereof, and whether, having done so, he was asked to sign. The witness was then asked to identify, with reference to his signature, that the statement in question was in fact the statement he made. Once confirmation of this has been obtained, counsel proceeded to go through the whole statement with the witness. That is the only procedure, my lord, which up to this end, which up to this far, a witness can be, that the credibility of a witness can be challenged on the basis of his witness. There's nothing other than this. And this is exactly what I actually tried to find out from Mr. Kwabeni when I asked him about the processes of how a statement is being made. That was not laying the foundation of the statement. The cross-examiner still had that duty to lay this foundation as it was enunciated in this case of Moses versus M, which quoted with approval the state of Govenda. This is the foundation that the state is supposed to be doing, my lord. And actually, my lord, all this which has happened here, the filing of the heads of argument and everything, my lord, we could have filed heads of argument from morning to the sunset, from January to December. So many pages. There is only one bridge that is supposed to be crossed. Is that bridge which is being enunciated upon in this matter of state versus Govenda, and which was approved in the case of state Moses versus the state, my lord. Let me proceed, my lord. Now, very interestingly, the state refers this court to section 190 of the Criminal Procedure Act, which relates to the impeaching of a witness. Section 192, my lord, it's also very succinct. It speaks to the process, or the provisions of section 192 speaks to the process that was enunciated in State versus Govender. May I just open my gadget, my lord, because I specifically want to read those provisions to the court, my lord. Opening my gadget. Thank you, my lord. I'm getting there. Okay. My apologies, my lord. I'm getting there. I'm getting there. Thank you, my lord. I'm now in section 90, just a second. Now, my lord, as it is the court, my lord, this is what the provisions of section 192 say. Open quotes. It says, any such party who has called a witness, who has given evidence in any such proceedings, whether that witness is or is not, in the opinion of the court, adverse to the party calling him, may, after such party or the court has asked the witness whether he did or did not previously make a statement with which his evidence in the said proceeding is inconsistent, and after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, prove that he previously made a statement with which such evidence is inconsistent. Now, the operative word in that section, my lord, that are very relevant to these proceedings or to this application by the state are as follows. And after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, prove that he previously made a statement with which such evidence is inconsistent. This simply means he who wants to challenge a witness on the basis of his previous statement has got to prove that statement, has got to lay the foundation of that statement. This is also contained in the very same provisions that the state referred to the court to, my lord. Now, there's something, my lord, that the state also referred to. The state also referred to a portion of Mr. Kwabeni's evidence. And I want to be sincere, as I would be referring this court to that evidence, my lord. But let me quote it first, and then I will come and unpack it. Now, on paragraph 3.4, my lord, this is what the state read to the court. The state read to the court that Mr. Kwabeni testified to the court as follows. He testified that he asked them to transfer what Mnisi has said to the document, in brackets his statement. He then wrote an S on that document. Sergeant Mukhula showed him a picture on the phone depicting Mafiga, that is now accused number 2. That is exactly what the state read to the court, my lord. But that was misleading. That was extremely misleading. And I don't want to get into issues of ethics and otherwise, my lords. But this is what the states are saying in their heads of arguments, open quotes. He testified that he asked them to transfer what Mnisi has said to the document, in brackets his statement. He then wrote an S on that document. He put an S as he had had enough of the assault and wanted to get away. That's the aspect that the state did not bring to the attention of the court, despite the fact that they are mentioning it in their heads of argument. Is that not misleading the court? As I'm saying, I don't want to get to the issue of ethics, my lords. Why did they omit to read that very succinct sentence that says, he put an S as he had enough of the assault and wanted to get away? They are creating to the court an impression that Mr. Kwabeni simply put an S on that document and that was it. And then from there, Sergeant Mukhula showed him a picture on the phone depicting Mafika was accused number 2. Why are they afraid to mention the report to that S because he was being assaulted? He wanted to get away from that assault. And the state simply decides to say, no, this you won't show to the court. Why? It's very suspicious because they know what the consequences of those are, my lord. It does not take any particular intelligence to understand what the consequences of these are. Now, the Makara case. Now, they say Mr. Kwabeni said, and this has got nothing to do with his application, my lord. I am simply responding because this was raised by the state, but it's just a collateral issue. It is not even a factor probante, effects that are relevant to the facts in issue. No, this has got nothing to do with that. But let me respond, because I simply want to clear the mist. The state says Mr. Kwabeni told, the state says, according to the version of Mr. Kininda, Mr. Kwabeni could not come to court because he feared for his life. That is what the state said. Now, that information from Mr. Kwabeni, from Mr. Kininda, Brigadier Kininda, it's a hearsay. And the credibility of that information depends on what the originator of that information would come and say. Mr. Kwabeni comes to court here, and I specifically put to him, Mr. Kwabeni, the state has told the court that you did not come to court, come testify on the behalf of the Section 204 because you are afraid of your life. Mr. Kwabeni says, no, they are lying, blatantly lying, because I have been to their offices 3 times. Actually, for the 3rd time, I had to hire a vehicle to come to court here on myself. How could then a fearful person, a person who was fearing for his life, would have done that? And this is the owner of the information that has been peddled at court, in a sense that he's afraid to come. No, he says, no, that's a lie. I went to their offices. They are the ones who actually have been chasing me away in all the instances that have been here. For the first time when I came here, they read some statement that I couldn't understand, and I told them, no. Not in my name. I would not be agreeing with what you want me to go and do, because then you're saying to me I should go tell the court something which is not real. Then they said, no, go back and think. And that is done in concurrence with the prosecution. Very sad. For the second time, that is also done with the concurrence of the prosecution. Very sad as well. For the 3rd time, goes to the office of the Director of Public Prosecution, as per the arrangement of the prosecutors and investigating team in this matter. He comes to court here. One of the investigating trial Sergeant Mukhula says to him, Kwabeni, go. Please, we don't want you here. Go. Why are they chasing him away? Why are they chasing him away? Because this is their Section 204 witness. A Section 204 witness, according to them, comes to them and say, no, I'm here. Can you please take me to court? I'm eager to go and tell the court what I know about this case. Then they say, no, Mr. Kwabeni, can you please go. I would have imagined how Ms. Mukhola actually said that, Mr. Kwabeni, please do not make noise. Let us not make a scene. Can you please go. That is what they did. Then they leave him in a ledge because they realize that he was not a good witness for them. And not only not a good witness for them because he had to come and change what he had initially told to them. No, simply because he told them nothing. He had to come here and speak to what he knows about this case. But because of the efforts that they've tried in vain to sway him, to say things that he did not know in favor of the state, they could not hold him. He became a hot potato in their hands. That is the reason why the state decided not to use him as a Section 204 witness. And they made him available to the defense. Then the defense picked him up from the trash place, cleaned him and said, Mr. Kwabeni, you will not be coming to testify for us. You will be coming to testify about what you know in this case. Can you please come and assist the court to come to a just, equitable, and a justifiable finding? He came and testified. As I've said, my lord, the state is requesting this court to embark on a process which is a trial and error process. These accused here are not guinea pigs. Are not here as guinea pigs. The procedure is very specific. Prove the statement, establish the basis of the statement, and then proceed to do whatever that you want to do with that witness. The state says the interest of justice dictates that I don't refer to that shake matter. They're referring to Hepworth, they're referring to the shake matter, referring to the multi-choice matter. They're referring to a whole lot of array of matters, the Zamini, the others, Jubert and Skitechat. They are saying it is in the interest of justice that they be allowed to cross-examine on the content of the statement that allegedly Mr. Kwabeni made. But still, who said that they cannot do that? Nobody said that. There is only, however, one test that they have to pass or fail before they get into the statement of Mr. Kwabeni. And that is what this was all about, my lord. And very interestingly, I remember now, on Tuesday when we reconvened, when the state had to start to make submissions, then the court said, Mr. Baloyi, we basically, yes, so that you can prove the statement, not so. They said, no, my lord, I've prepared head of arguments. And then the court said, no, but Mr. Baloyi, we would be expecting you to prove that statement. Then said, no, my lord, I think we had agreed with my colleagues that we should file heads of argument. I've already done that. And then may I be allowed the opportunity to go through my statement. Then the court, I think, in his brilliant mind, gave him the benefit of a doubt, thinking that probably he will come up with something extraordinary, exceptional, that will demonstrate that maybe there's another process that he would have come up with based on authority, well-recognized authority, through which a witness statement could be embarked upon in trying to deal with the content of such a statement with a view to try and prove the credibility or to discredit the witness who is alleged to have made that statement. As I've said, my lord, in the context of my submission, none of that has come. We still back to square one. Prove the statement. I would therefore submit, my lords, as I end, that fairness of a trial simply also dictates, in respect of the cases that the state has referred to, the Hepworth, the Shakes, the Skitterhat, the multi-choice, the Daminis, and etc. These are all cases that basically refer to the concept of a fair trial. And indeed, the fair trial also dictates that if there's a specific procedure that has been tried and tested and it is in place and it is authority, that procedure cannot be deviated upon for flimsy reasons. Number one. Number two, stare the cases, my lords, as fakir non-mawere. In other words, do not change what is standing. Do not move what is being regarded as law at that particular moment in time. The state had not brought forward any specific authority to say, this is my authority. We're now moving away from the fact that if I want to discredit this witness, then I can simply embark upon that without proving that statement. Fairness of a trial also dictates that if there's a standing process that has been recognized for all these years and it is authority, such should be complied with, my lord. Otherwise, the processes that are put in place in order to safeguard the smooth of trials and everything will be turned into a mockery if in one circumstances one party goes to the east, the next time it goes to the west, the next time it goes to the east, and Mpumalanga njalo njalo. No, that is not like that, my lord. As I conclude, my lord, I would therefore humbly submit that there's nothing that the state has come up with here. There's nothing new subsequent to the submission that I made earlier on, which was based on my objection that the state has come up with here. Even now, the state has not made any case for an exception to the rule, which is prove the statement before you get into it, my lord. Thank you.